Ready for the dictation? 5 seconds to go. Start. There is no cavil over the fact that the grant of leadership in favor of the appellant was cancelled by the committee and that received the stamp of approval of this court. Stop. After the decision of this court, the corporation terminated the leadership and intended to take back the possession from the dealer with a view to appoint another dealer as specifically permitted in the lease deed as well as in the leadership agreement. The appellant built a wall to stop functioning of the retail outlet and refused to hand over the possession, which constrained the corporation to initiate a proceeding for eviction under the Public Premises Eviction of Unauthorized Occupants Act 1971, for short, the 1971 Act, as a valid lease deed existed between the appellant and the respondent, a public sector undertaking. Stop. The appellant participated in the proceeding and after hearing commenced, he sought to go for arbitration, but the said prayer was not accepted by the estate officer on the ground that the same was not permissible under the provisions of the 1971 Act. Stop. After 6 years participation in the said proceeding, the initiated a civil suit alleging illegality in termination of the lease and prayed that the proceeding under the 1971 Act to be kept in abeyance, which was not accepted. Stop. The content authority, that is the estate officer, passed an order of eviction in exercise of powers conferred on him under subsection 1 of section 5 of the 1971 Act after rejecting all the contentions raised by the appellant. Stop. Being aggrieved by the aforesaid order, the appellant preferred civil appeal number 92 of 2013 before the learned district judge Rewari under section 9 of the 1971 Act. Stop. It was contended before the learned district judge by the appellant that the order passed by the estate officer was passed on surmises and conjectures that the estate officer that had failed to appreciate that the lease deed and the leadership agreement were interlinked and hence the lease deed could not survive after the cancellation of dealership agreement, that the 1971 Act was not applicable to him as he was not in unauthorized occupation but is the owner of the premises, that the content authority had directed order of eviction to circumvent the eventual result of the pending suit and that there had been violation of the principles of natural justice. Stop. The learned appellant judge, on the basis of the material brought on record, came to hold that the respondent is a government company and the premises were taken on lease by it. Stop and over.